Welcome back. This morning I thought I'd go through this comment with you because it highlights many of the misunderstandings regarding council tax. So whether this was left argumentatively or genuinely to ask questions matters not. I'll go through it and I will do my best to answer them in a way that is clear to you all. So this opens up with, which Act of Parliament authorises the council to establish its own court? So let's deal with that one first of all. It doesn't. The councils do not establish their own court. What they do is they book or they arrange a hearing room where the court will go through a list of alleged debtors who have not paid their council tax. And then they are invited into court to make their representations. And if they don't turn up, invariably, the court is going to make a liability order against them in their absence. But if essentially the court goes through a list of alleged debtors in a room which is organized because of the sheer amount. There's usually thousands of these on a list, which is why it is handled in the way that it is. And the higher courts have criticized the process, to be fair, because in any process like this, you would expect a party against whom an order is being made to be given the opportunity to come in and make representations, which they are, of course. But when they don't, it's just made in their absence. And then there's one general order made deemed to be against every person on that list. So assuming that that is clear, rewind, watch it if it isn't, but assuming that that's clear, that answers the first question. Local authorities, councils do not establish their own court. They're all heard at the magistrate's court because it is still one of these things that is heard in that sort of court. So moving on, which Act of Parliament authorises the council to appoint a representative as a magistrate? Again, they don't do that. They might appoint a representative working for the local authority that goes to represent the case on behalf of the local authority, but they don't appoint a magistrate as a representative. That's just a fallacy with respect. That's a false statement or a false presumption there. Again, reading this first sentence, which Act of Parliament authorises the council to issue liability orders? Now, technically, the local authority is not granting a liability order. That is deemed to have been made against the alleged debtor by the court. Although the court doesn't physically print out this liability order, it, again, matters not. It's deemed to have been made. Just like if a high court judge were to say, from this point forward, Mr. X is not to do that thing, that from that moment those words are uttered, it becomes an order of the court. The fact that it is then translated into a sealed order and served, however it might be served. For example, let me give you an example. We've had a case I've been involved in. It was an international kidnapping of a young child, and the child was going to be removed from the UK to another country. And it was an urgent hearing. This is one of those where you get on the telephone, you get a high court judge at sort of 10, 11 o'clock at night to say that we need this order to prevent this child from being removed so that the order can make its way to customs to prevent the child boarding the plane and so on. As soon as the judge, even over the telephone, says, yes, I agree, I will make that order, it becomes an order. Then if you as the lawyer, simply even by WhatsApp, I think this one was in the end, message the other party and say, there is a high court order that this child is not to be removed from the jurisdiction. It's an order of the court and it will be contempt of court for somebody to disobey it. Just because it isn't in a physical paper form doesn't make any difference. Back to liability orders. As soon as the order is made verbally, I will make that order against the list of alleged debtors, then there is a liability order existing from that moment forward against each of those named individuals. The local authority then will issue an order. Now, one of the problems in the previous case that I talked about was that the local authority then just told a debt collection agency that you have our authority to chase these debts because we have a liability order. The higher court eventually said, well, that's not good enough. You can't just, as the debt collection company, you can't just go and enforce these debts without having a copy of the actual order. You can't just take their word for it. So that's what that was all about. Reading on, potentially bypassing due to a process in an independent and unbiased court. Well, obviously, that's not going to happen for the reasons I've just said. It's not going to be an unbiased court because it's just the standard court. It's not any different court. and it's not bypassing the usual process. So it is an independent, all of the judiciary is independent, all of the court system is independent, and so all of these are heard in an independent, non-biased court. Moving on. Under which Act of Parliament, we're reading from this second bit down here, from here, under which Act of Parliament can a council issue its own liability orders without a contract or consent between the parties involved? Now, again, just with the recap that the local authority is issuing an order which has already been made by the court. So the council is essentially just producing the order based on the court order, if that makes sense, based on what I've just said. However, the second bit is what I'm dealing with here. Without a contract or consent between the parties. That is not how council tax works. Council tax does not depend on a contract or consent between the parties. So it is actually the Local Government Finance Act 1992, which I can bring up now, which is where council tax is derived. So I've mentioned this before. Council tax in respect of dwellings, the meaning of a dwelling, what is chargeable, and who is liable, persons liable. You go into Section 6. This provides who is liable to pay it. Now, I know some people say acts are not law and all of these sort of arguments. That is just simply untrue. It's a fallacy. It's a silly argument that is never going to get anywhere because acts of Parliament are primary law in the UK. So the Local Government Finance Act is what sets out the liability to pay council tax. If there's any confusion over that, this is where you look to. We'll come back to enforcement in a moment. But for that reason, this, with respect, is again wholly misconceived. There is no need for an Act of Parliament to provide councils with any sort of contract or whatever consent. There is no consent required. There is no contract required between the local authority and the parties involved. Again, it is deemed to be a liable person if they fall within the definitions within this Act. Moving on. Given that liability orders are based on legal presumptions, which is in part true, by the way, it's a legal presumption that there is non-payment of council tax because it is a presumption until it's either proved or disproved. There are certain things that we call a rebuttable presumption, meaning it's presumed to be true unless you provide evidence to the contrary, which is possible in this situation. Some things are not rebuttable, but we've covered those in other videos. So given that liability orders, this says, are based on legal presumptions, i.e. the presumption that the person has not paid council tax and a liability order has been made, why should they not be dismissed once these presumptions are successfully challenged? Well, this is the very reason I say don't ignore things, don't bury your head, and don't just ignore the problem. If you ignore the problem, it will get worse. Just like if you ignore one of these, a notice that it's going to be heard by a single justice procedure, if you ignore it, it will just go and get heard in your absence. You'll be convicted in your absence on the single justice procedure. So ignoring things makes it worse. So the key wording here, successfully challenged. Well, by default, by definition, if you have successfully challenged something, then it will be dismissed. If you have a liability order made against you for non-payment of council tax and you successfully challenge it because you didn't ignore it, then it will be dismissed. How could you successfully challenge it? Well, if you are not the person who should be paying the council tax in the first place, and bearing in mind just saying, you don't consent to this law or anything, all of that nonsense, that's not going to wash. If you are the person on this list, which is likely if you're living in the dwelling unless you're exempt, but if you're the person here, you're likely to pay it. If you're not the person, if you weren't living there, for example, you weren't living there at the time, if you moved out at the end of March and let's say you get a liability order against you for June and July when you were not living there, but you had, because you didn't turn up or whatever, you had a liability order applied for against you. So they're seeking a liability order against you for June, July onwards. You could turn up, which is why you should turn up. You could turn up and successfully challenge it to say, I moved out in March. I had a tenancy, or I sold the house in March, or tenancy up until March. And June and July, not me, not my problem. It was nothing to do with me. Go find whoever owned the house or rented the house at that time. It was not me. Then you would successfully challenge it, and then a liability order would not be made. But if you don't turn up and you're on that list, you can bet that you will have a liability order made against you, and then all of the enforcement will ensue, which I'll come back to in a moment. So reading back that question again, why should they not be dismissed once these presumptions are successfully challenged? Well, they will. They will be dismissed if you successfully challenge it. But if you don't challenge it in the first place, it's not going to be successfully challenged. Moving on. Additionally, how can a liability order be valid if issued by a non-existent court? Well, as we covered earlier, that's not the case. They are not issued by a non-existent court. They are issued by the court, and the local authority turn up with a list. They apply for liability orders under the enforcement sections that I'm going to come to in a moment. For a court's legitimacy, this goes on. There must be either contractual agreement, which is not true. There is no requirement for a contractual agreement between a party and the local authority for the court to have any legitimacy here. A tort committed, well, that's not true either. It's just a breach of the statutory requirement to pay council tax, or a crime. Well, non-payment of fines would amount to a crime. Non-payment of the council tax is just a liability for which they will obtain a liability order. The clue is in the name. So this whole statement really is false for court legitimacy. So in other words, this comment says that for a court's authority to be legitimate over you, the person, there must either be a contractual agreement, which there doesn't, a tort committed, or a crime. Now, if we're talking about you've committed a robbery or arson or something else, then yes, the court's legitimacy over you will be because you've committed a crime. And there will be either common law or, there are many common law offences that still exist, a great many, or an act of parliament that specifically criminalises certain behaviour. And there's lots of those. So it's not just because you committed the crime, it's because the crime by definition, either by common law or by statute, is a crime and therefore makes the court legitimate. None of which is anything to do with council tax, because it's nothing to do with contracts. It's not a tort as such. It's a breach of statutory duty to pay council tax, and it's not a crime unless you're not paying the fines for which, and then it can become a crime. On what basis does the council rely on to enforce council tax or any tax, and where is this stipulated in law? That's where I bring you to the bits of law that I'm going to explain. First of all, so great comment, if made genuinely or disingenuously, I'm not sure which, but either way, useful comment to respond to clarify some of these questions, which many people might have. What basis does the council rely on to enforce its council tax or any tax, and where is it stipulated in law? Well, there are, first of all, dozens of bits of legislation, primary law, upon which the council will rely to enforce various taxes, including council tax. Now, the application of council tax in the first place, as I say, is from the Local Government Finance Act, council tax in respect of dwellings, and so on and so forth. Now, as to the enforcement, you'll find this in with various amendments in the Council Tax Administration Enforcement Regulations, 1992. And specifically, this talks about various sections with information from residents, exempt dwellings. So you might have an exempt dwelling, certain discounts, billing, how the billing works, payments, failure to pay, lump sum payments, when you can lose the right to pay in installments, and so on. But then specifically, the question asked about enforcement. Now, the enforcement is dealt with from 33, 34, 35, 36, the duty of debtors subject to a liability order. So the local authority will apply for a liability order under this section if an amount which has fallen due is wholly or partly unpaid. The amount stated in the final notice is wholly unpaid, etc. The court can apply for to the magistrate's court for a liability order against the person by whom it is payable. So this is the section the local authority will apply to the magistrate's court for a liability order. It is just effectively an order whilst not a physical order, as I described earlier, the court doesn't print a physical order. It just prints a confirmation that this has been made. And it's not always clear by whom that has been made, and the higher courts have criticized that. So to be fair, there is a criticism within the system, within the court hierarchy of this system. That, obviously, I've commented on in other videos. This is not a defense video of councils and council tax and whatever. This is just a helpful guide to you to understand where this comes from based on that comment. But then the duty of debtors subject to a liability order. So that those against whom a liability order has been made. Where a liability order has been made, the debtor against whom it was made shall, during such time as the amount in respect of which the order remains wholly or partly unpaid, be under a duty to supply relevant information to the billing authority on whose application it was made. So you have to provide the local authority with information as to who's your employer, what are your earnings, and all of these kind of things, and your income. The reason for that is that the local authority can then apply for an attachment to earnings. That is where money is deducted before it comes to you by your employer. The employer will be under a legal obligation to deduct money that they would otherwise pay to you and then pay it against this order instead. So where a liability order has been made and the debtor against whom it's made as an individual, the authority which applied for the order may make an order under this regulation to secure the payment of any outstanding sum, which it forms part of the amount of respect, etc. And so that is where the law comes from. That is hopefully an answer to this question here. On what basis does the council rely to enforce council tax or any tax? As I said, there are dozens of bits of legislation. These are just one or two of them. This is where council tax arises, and this is one of the bits of legislation under which council tax is enforced by local authorities. I hope that's useful. I hope that is a valid answer, and I've answered these questions succinctly and correctly. If you do find these videos useful, please do subscribe. I know about 60% of you don't. I know you think it might not help, but it does help my channel if you subscribe, because it helps my channel grow in that it will reach a wider audience. The more people that like the video and comment and then subscribe and share it with somebody, all those kind of things, it all helps. It all spreads to a wider audience. I'm really grateful for that. I'm doing this on a Saturday morning for you because, one, because I enjoy doing it. I enjoy helping you out. And I like to know that people have these questions answered. So with that, I thank you for watching and have a great Saturday. See you next time.